Today's video feature is how do we go about picking a jury in a South Carolina criminal case, and more specifically a DUI case. Now, every case is different, every jury pool is different, but the process remains pretty much the same. I'm a big fan of South Carolina procedure. I think it's efficient. I think it's effective. Now, the goal in picking a jury is to find 12 folks who can be impartial and hear the evidence before reaching a decision or drawing a conclusion. And they have to be fair to both the state of South Carolina as well as the defendant. And so how do we go about finding those individuals? Well, first the judge comes in, introduces himself, introduces the court personnel, the lawyers, the defendant, and explains the roles of each of those individuals. Then he asks some preliminary qualifying questions. To be on a jury, you have to be at least 18 years old, a citizen of the United States, and you cannot have any felony convictions on your record. After that, the judge will explain that we are here to find an impartial body of people who can be fair to both sides. He'll give some preliminary instructions about does anyone have any questions or concerns about whether they could sit in judgment, any moral prohibitions or positions that would enable them to not be fair to both sides, if they have any issues particularly with drinking, if they belong to groups like Mothers Against Drunk Driving and so forth. And then, of course, the lawyers will have submitted before court some more specific questions, and each law firm has their own individual questions. Now, once we go through all of those questions, if someone does have an issue or needs to respond to any of the questions, they will simply raise their hand. Then when we have all the questions asked, then everyone who had to raise their hand will come up before the judge and explain what the particular issue is. Both the defense lawyer and the prosecutors are also standing there to hear the potential juror's response. Then based on that information, they go back and sit down unless they are excused for cause, and that is a decision made by the judge. Now, once we have a jury pool qualified, then they go back and sit down and they are chosen at random. They come up to the front of the court. The state first has the ability to accept or reject. If they accept, then the defense has the ability to accept or reject, and each side has a certain number of preemptory strikes that will allow them to excuse a juror for anything other than some type of discrimination. So if a defense lawyer or the prosecutor thinks that a juror is not particularly good for their side and they have enough strikes left, then they can excuse that juror. Again, anything for cause should have been dealt with before we start actually picking the jury. Once we get 12, then we pick an alternate, the same basis applies, and then we are ready to begin our trial. At that point, it is now in the hands of the jury until the case is closed and the judge renders the ultimate jury instructions, and then they get a deliberation and verdict. Now, that's a lot of information. I hope it was clear, but if it was not, if you have additional questions, feel free to reach out to me. My name is Robert Reeves. My mobile number, 704-351-7979, or email robert@rjrlaw.com. Thank you.